We got Jerry. We got the A team here.
Fitzgerald, one to work for Marshall McLennan.
You all set, Jerry? All set?
Yeah, last year I watched more. This year I just was easy, but
Yeah, last year was the Big Ten.
This meeting will now come to order. This is the September 11th, 2012 meeting of the Town of Fairfield Town Plan and Zoning Commission. We will begin by going into executive session for several items. The members of the public that are here, we will have a public hearing immediately after the executive session. There's one item on public hearing, the continuation of the hearing regarding the application of James and Brian Sakonchik proposing a new section 7.0 set-aside development, which was begun August 28th. Heard concurrent with an application of Mr. Sakonchik for a site plan approval for a 3-unit residential development pursuant to 830G of the Connecticut statutes at 206 Homeland Street. In executive session, first item are the meeting minutes of August 28th, 2012. Is there a motion?
a motion to approve.
Thank you.
I'll second.
Commissioner Barrett has moved to approve. Commissioner Suter has seconded. Are there any additions, corrections, or deletions to those minutes as submitted? Hearing none, all in favor of the minutes, August 28th, 2012, signify by saying aye. Aye. Opposed? Abstentions?
Abstain.
Thank you. Commissioner Wagner has abstained. Minutes are approved unanimously with one abstention. Next item, 3171 Bronson Road, referral from the Board of Selectmen for the sale of town property to eliminate a driveway encroachment. Mr. Wendt?
Okay, this is a referral pursuant to Section 8-24 of the Connecticut General Statutes. You're not giving a yes or no vote. The RTM will ultimately have to render a decision on this, so you're giving them a referral either positive or negative.
Could I ask you all to use the microphone?
Is it working?
You have to speak into it.
We understand that, sir. Thank you.
It's right here. This is a 2,827 square foot parcel proposed to be purchased to eliminate a driveway encroachment. You've got a reduced version of a survey, and you've got an aerial map that we prepared showing the relative location of this driveway. The house at 3171 Bronson is in the midst of a sale, and they discovered this encroachment. The Board of Selectmen has already voted to endorse the proposed sale of this 2,800 square foot piece to eliminate the driveway encroachment, and it's going to be up later this month on the RTM calendar.
Thank you. Is there a motion on this item? The motion would have to be to have a positive or negative recommendation. Is that
Right.
correct?
You're simply making a recommendation to the RTM whether you are inclined to agree that this is a positive thing or vote to make a negative referral that the town should maintain ownership.
Thank you. Commissioner Suter?
Yeah, I'll move to make a positive recommendation to the RTM.
Thank you. Commissioner Suter has moved for positive recommendation to the RTM. Is there a second?
I'll second.
Thank you. Commissioner Jacobs, any discussion? Commissioner Suter?
Yeah, and reviewing Mr. Arrow's letter and studying the plans and the photograph, it seems obvious that land is of no benefit to the town, and it will solve a title problem for the landowner. It seems to be I would say, a win-win situation, to use a phrase, for both the town and the landowner. So I think we should recommend it.
Thank you. Is there any further discussion by any member of the Commission? Hearing none, all in favor of the motion, which, as you know, is a motion for a favorable recommendation for the acquisition, or I should say, for the sale of town property to eliminate the driveway encroachment, signify by saying aye. Aye. Opposed, abstentions. And Commissioner Neely, you're on for Commissioner Jacobson this evening. Thank you. Next item is new applications to refer to public hearing. First item is 2226 Black Rock Turnpike, special permit application of Clearview Holdings LLC and Cleban Clearview LLC pertaining to additions and alterations to an existing commercial building in a designed commercial district. Mr. Wendt?
This is the Fairfield Pool Building. It's been sold. They're looking to actually make this building smaller. They're going to demolish the second floor and do some additions on the first floor and reface it, but the net result will be a reduction in square footage. But it does require a special permit because there's change to the footprint and the overall site plan.
Thank you. Is there a motion on this?
I'll make the motion.
Thank you. Commissioner Wagner has moved that this matter be recommended to public hearing. Is there a second?
I'll second, Mr. Chairman.
Thank you. Commissioner Kennelly has seconded. Any discussion? Hearing none, all in favor of referring this matter to public hearing signify by saying aye.
Aye.
Opposed, abstentions, item carries unanimously. Next item, 41 Fairfield Beach Road, special exception and coastal site plan application of Fairfield Beach Club Incorporated to replace the existing paddle tennis warming hut in an A zone. Mr.
You
Wendt?
may recall that last year, this commission approved the replacement of the junior clubhouse, as they called it. There's a smaller structure on the easterly end of the property. That's the paddle tennis hut that needs to be replaced, so it requires a similar special exception application.
Thank you. Commissioner Jacobs?
Just for the record, I'm recusing on this item.
Thank you, Commissioner Jacobs. That means that Commissioner Parker is on this item for Commissioner Jacobs. Commissioner Neely remains on this item for Commissioner Jacobson. Is there a motion on this item?
I'll move to public hearing.
Thank you. Commissioner Kennelly has moved this item to public hearing. Is there a second? Commissioner Neely has seconded. Any discussion? Commissioner Barrett?
Just a question for staff. Do we know if this is going to have any kind of a second story or height to this building? Are we seeing
It's
any
not
plans?
any taller than it is presently. As far as I know, the applicant has sent plans and the application to all the across the street neighbors in advance. They have it already for their review.
Okay. Because there was some significant opposition to the last one. They came to an agreement about what they, wouldn't do something for a certain
Understanding
time
that, they've
period.
already given advance notice to the neighbors with sets of plans.
Thank you. Is there any further discussion by any member of the commission? Hearing none, all in favor of this item, 41 Fairfield Beach Road, signify by saying aye. Aye. Opposed, abstentions. Item passes unanimously and is referred to public hearing. On the compliance calendar, we have two items. First, 65 Commerce Drive, zoning compliance and coastal site plan application of UAG Fairfield CM LLC to expand off-street parking in a design industrial district. Mr. Wendt?
Okay, you've got a fairly cumbersome set of plans for parking lot expansion in front of you, but basically, this is the site of the former Laidlaw Bus Terminal down on Commerce Drive. It's been vacant for quite some time. The United Auto Group is seeking to expand their off-street inventory storage. In May of 2010, this commission approved a similar expansion. The current plan seeks to further expand the parking area and provide pavement, drainage, and streetscape improvements similar to the previous plan that you had approved. No curb cuts are proposed, as access will be from the adjacent parcel. And the drainage proposal will result in water quality improvements with the implementation of the plan that they have. So it's using another chunk of that adjacent piece for additional inventory storage for United Auto Group.
Thank you. Is there a motion on this item?
I'll move to approve it.
Thank you. Commissioner Barrett has moved to approve. Is there a second? Commissioner Neely has seconded. Is there any discussion? Do we have the information on the light fixtures on this they're putting in, do you know?
Yes, there is. It's within one of the latter sheets. I'm glad you raised that because they're showing, I believe, the height of 27 to 28 feet and the max is 25 feet. So they
Right.
need to cap out at 25 feet.
Yeah, that was exactly my concern, the height and the dark sky nature of this.
Yeah, I believe they're showing
couldn't
completely down, vertically oriented fixtures, so I don't think that's the issue, but they do show their height of their fixture to be at 27 or 28 feet, if I recall correctly, and the max is 25 feet. But if you wanted to further bolster that, you could potentially require that the fixtures be fully cut-off fixtures as what we typically look for with a maximum height of 25 feet.
I think the height, you're right, they're 27.0 here. I think we have to keep it at 25. And, yeah, I think we need the cutoff because these don't appear to be shielded from what I'm looking at. I can't tell from their schematic.
Yeah, so I would recommend that if you're inclined to approve the plan, is to impose a condition that they be fully cut off fixtures with no protruding lenses no higher than 25 feet.
Give everyone a minute to look at this to see if anyone else wanted to go through their notes too. Okay, any other questions? They're not planning to put any razor wire on top of this fence, are they?
No.
Commissioner Wagner?
Yeah, thanks. The plan actually does note that there is a chain link fence with razor wire to remain at the southerly portion.
That's correct. If you look at sheet number 2 of 6, site and landscape plan, Commissioner Wagner is correct.
But there's, to the extent that it exists presently. Right. I don't believe they're proposing any new fencing at all.
I guess that's against the train tracks.
Right.
So what about internal landscaping or beautification? Is that anything that was considered by the applicant, do you know? I mean, for lighting wells or tree shade trees or anything like that.
Commissioner,
I don't, when we approved the sales lot for the dealership last year or the year before, I forget, I don't think we required any landscaping for that because it was basically a commercial parking lot. It was not
Right.
sort of a customer parking lot. And I think the same would be true for this lot, which seems to be a logical and good use for the land. Also, they're apparently improving the drainage on it, which Laura Pooley has approved and in her report. And the coastal area management study finds no problems in that area either. So it seems to be something that we should probably approve.
Yeah, I mean, it's hard to get too excited about a parking lot, but here you've got a parking lot replacing like piles of fill and, you know, unused concrete slabs, and
Yeah.
now it'll be a paved parking lot with some landscaping in it and so, you know, some mitigation for runoff, so it's an improvement. Again, it's hard to get too excited about a parking lot, but it's better than something that's really dilapidated.
is there any further discussion by any member of the commission? Does someone wish, who moved this item? Was it Commissioner,
Seth and Joe.
Commissioner Barrett? Do
Yeah.
you wish to
I'll
add that
amend.
conditioned?
Yeah.
That the lights be fully cut off, no protruding lens, dark sky compliant, and no more than 25 feet high pursuant to our regulations?
I would like to amend my motion to include those conditions.
And
yes.
Commissioner Neely, does your second agree with those same conditions? Thank you. Is there any discussion of the item with those conditions? Hearing none, all in favor of this application with those 4 conditions: fully cut off light fixtures, dark sky compliant, no protruding lenses, and no more than 25 feet, as required by our regulations, signify by saying aye.
Aye.
Opposed, abstentions? Carries unanimously. Next item, 1838 Black Rock Turnpike, application of Gary Azarian to establish an indoor recreational facility, personal training in a portion of an existing building in a designed commercial district. Mr. Wayne?
Okay, this building is at the corner of Black Rock Turnpike and Burroughs Road. It's presently a 3-story mixed-use building, retail on the first floor and 2 floors of residential. This space is most recently occupied by TD Bank on the corner and a Carvel store. It's been vacant for a while. Those two spaces are proposed to be combined for this use. It's an interior fit-up only. There's not going to be any exterior changes to the building for a fitness use. The parking is the same as that for the bank and the retail, so there's no new demand for increased number of parking spaces, and there's no exterior, so it's just what they're looking for here is just the change in use from retail portion and a bank to indoor recreational facility, fitness facility.
Any information on the sign plan on this? Is that going to be coming to us separately?
The sign plan for the building calls for individual channel letter signs, so if they are looking to comply with the existing plan, then that's something that we would deal with administratively. If they're looking to do something off the menu, then they'd have to revisit that with this commission.
And they've indicated nothing to staff yet, correct?
Not at this point.
Thank you. Is there a motion on this item?
Move to approve.
Thank you. Commissioner Jacobs has moved to approve. Is there a second?
I'll second, Mr. Chairman.
Thank you. Commissioner Kennelly, any discussion? Hearing no discussion, all in favor of 1838 Black Rock Turnpike, application of Gary Azarian to establish an indoor recreational facility, personal training in a portion of an existing building, designed commercial district, signify by saying aye. Aye. Opposed, abstentions. Item carries unanimously. There being nothing else in executive session, we will come out of executive session and recess for 5 minutes to reconfigure the rooms for the public hearing. So we stand in a brief adjournment. We're back in session again. This is the September 11th, 2012 meeting of the Town of Fairfield Town Plan and Zoning Commission. We're going to begin our public hearing for this evening. There are two items on public hearing which we are considering concurrent with each other. The first is zoning regulation amendment, application of James and Brian Sekonchik proposing a new section 7.0 set-aside development that was begun August 28, 2012. The next item, 206 Homeland Street, application of James and Brian Sekonchik for a site plan approval for a 3-unit residential development pursuant to Connecticut General Statute, Section 8-30G, also continued from August 28, 2012. The order of proceedings on August 28th and this evening are the same. We begin with the applicant. The applicant began on August 28th and did not finish his presentation, so he'll be allowed to continue today until he's finished. Following that, we will have staff comments. We'll then go to the public for public comments on the application. The public, again, is allowed to raise points and raise questions. However, the applicant does not answer questions to the public, nor does the commission answer questions of the public. It's merely a public comment section. We then go back to the applicant for any final remarks and concluding statements. At that time, the commission can ask Mr. Sekonchik any additional questions or issues that may be raised by the public. And again, to remind everyone, this is an 830G application. It's under Section 8-30G of the Connecticut General Statutes. That's a state law. It's not a local law. It's not in our zoning regulations. It's a statute, a public act enacted by the legislature in Hartford, and it is still in effect in Connecticut. And it's different than a subdivision application or a zone change application or a special permit or a special exception application. There must be evidence of a substantial public health or safety issue or other matters that this commission can legally consider in order to warrant a denial of this application. Again, there has to be evidence of a substantial public health or safety matter or other matter that we can legally consider in order for the commission to deny this. Those public health or safety or other issues must clearly outweigh the need for affordable housing under the law in Connecticut as set by the statute and the case law interpreting it. And the decision of this commission cannot be based legally on impacts on property value, on schools, on neighborhood aesthetics, or things like that. And just so the public is aware, this is different than our usual application, so the questions are a little different and the standard is significantly different than what you may be used to from our other public hearings. That being said, thank you for your emails. Again, I read them into the record last time. We have some additional items in the record. I'll just reference them since the last meeting. The first is we did receive a drawing. It's entitled Site Plan Proposed Dwellings for Lot 138 Stratfield Homelands, dated July 7th, 2012, sheet 211-067, Site 1. We have correspondence from Mr. Sekonchik dated September 6, 2011, entitled Storm Drainage Report for 206 Homeland Avenue, Proposed Residential Development. town requirements for development of lots. Attached to that is a diagram regarding test holes and borings, a photograph of the swimming pool, another diagram talking about and showing detention units and connections to drainage, a picture of a Coltech drainage structure, and a second page with a side view of that structure. We also have correspondence from Laura Pooley, the town engineer, part of the record, and correspondence from Mr. Sakonchik to Mr. Wendt, our assistant director, responding to comments of Ms. Pooley. And that's again dated September 11th, 2012. With that being said, Mr. Sakonchik, we'll let you continue where you were, sir.
For the record, Jim Sakonchik, applicant, here with my son, Brian Sakonchik, co-applicant. And can I be comfortably heard? Thank you. Mr. Wendt, one of the commissioners asked for the reference on that Judge Fuller's document. I didn't. Did you receive the fax and letter with that reference data on it? I just want to make sure that's in the record because that was requested by a commissioner.
I did.
Thank you.
The title page?
And I do have full-size copies for the record of some of the documents already mentioned. I'd like to submit those.
If you could just show them to me, I'll read into the record what they are first. These are the... Okay, the first is the September 6, 2011 storm drainage report. The next is the September 11th correspondence to Mr. Wendt from Mr. Sakonchik responding to Ms. Pooley's comments. And then there's a full-size plan of the file number 211067, site plan proposed dwellings dated July 7th, 2012. And a second sheet labeled property map showing proposed dwellings dated November 28, 2011, drawing P1. Thank you, Mr. Sakonchik.
And just to summarize, at the last meeting there was questions about how storm drainage is being handled on the site, and the substance of the reports related to storm drainage did address that issue, and I believe Ms. Laura Pooley did a favorable response to that, which we are comfortable with. She did talk about at the end of her letter saying concrete curbs and sidewalks are required in this zone, but I think that probably more applies to when new roads are being built, because obviously there are existing newly paved road there, there are existing bituminous curbs, and there's no sidewalks anywhere in the neighborhood, so I don't really think that applies to this particular application.
Could you just hold the microphone down a little bit? Yeah, just like, yeah, underneath your mouth so that you're not, right, thank you.
Thank you. So I believe that supplemental data completes our application here, and it completes my presentation at this time.
Thank you, Mr. Sakonchik. At this point, we will go to our staff for any staff comments on this application. Mr. Wendt?
Good evening. For the record, my name is Jim Wendt. I have two exhibits that I'm going to hand out that I'm going to refer to in my comments. Well, if you could just take one of each of these. I'm going to cover some ground that we covered at a previous meeting, but it's important, so I'll begin with the discussion of merger that was referenced at the last meeting. And I'm specifically going to talk about the history of the previous permit activity on this site, which reveals the following. All three zoning compliance applications, which are part of your record already, include both assessor's parcels. Had the previous owner wished to distinguish those parcels, they would not have been listed together on the applications. Similarly, all three applications were accompanied by a site plan indicating a single parcel of 10,000 square feet. And had the previous owner wished to distinguish the parcels, a combined site plan would not have been submitted. The pool setback issue that was discussed is really a red herring. The setback is irrelevant. It's simply not an issue. A pool is not a permitted standalone use on a separate piece of property. It has to be on a piece of property for a structure to which it's accessory. So whether its setback is conforming or not doesn't matter. It's not otherwise a permitted use on a standalone site. And perhaps most importantly, building across the parcel line is another clear indication of the intent to treat the lot as one parcel. The applicant, Mr. Sakonchik, submitted last time a letter dated January 25th, 2012 by an attorney, DeNorfia. I agree with the portion of that letter that indicates the intent of the property owner is important in evaluating merger. And what I've provided for you is a court case, Iannucci versus the Zoning Board of Appeals of Trumbull, which is a 1991 appellate court case that supports that proposition. I'll quote from page 4 of that decision. Contiguous land owned by the same person does not necessarily constitute a single lot. A merger can occur, however, if the owner of contiguous parcels of land intends to form one tract. The owner's intent may be inferred from his conduct with respect to the land and the use of which he makes of it. Now, in that case, as in this case, there was a portion of a building that was constructed across parcel lines. Further down on page 4, the Trumbull ZBA found, and the court found, it was reasonable for the defendant zoning board of appeals to infer that actions of the plaintiff's parents, who were the previous owners in that case, effectively merged the lots. And the court went on further. The plaintiff's assertion that the lots remain separate because they appear on the original subdivision plan is not persuasive. A reference to multiple lots from a map filed on the land records does not compel a finding of absence of merger. Such a conclusion conflicts with the basic proposition that the determination of factual issues of merger, the intent of the property owner must be ascertained, and that's essentially what we're demonstrating here. The facts presented with respect to the conduct of the previous owner of the Holman Street property, in my opinion, supports a finding of merger. Next, I'll refer to the case that the applicant provided last time in Appendix 3 of his submittal. He provided to us the court case of Holt versus the Zoning Board of Appeals of Stonington. And the argument there was that a letter from the zoning enforcement officer isn't necessarily an appealable action to the Zoning Board of Appeals. Well, if you delve a little bit deeper into that case, I think it further supports what we've been saying here. The court found in the Holt case that all letters by zoning enforcement officers interpreting zoning regulations and applying them to specific situations are not appealable pursuant to Section 8-7. Basically, the court was saying there it depends on the facts of each case. Not all letters, or opinion letters of the zoning enforcement staff, are appealable decisions. And it's important to note that there wasn't an application involved in that case. It was just an opinion letter that the zoning enforcement officer had provided. And at best, that case could be used as an argument as to whether or not my first letter that I wrote December 19th of 2011, which was the letter in which I opined that the property was a single merged lot, was an appealable decision. We don't need to worry about that argument, however, because Mr. Sakonchik took the next step. He actually made an application. He subsequently applied for a certificate of zoning compliance for a new house, paid an application fee, submitted plans. He acknowledges before this commission and in his paperwork that he is in receipt of my letter of March 19th denying his application. Now, it's important to make that distinction, denying his application, because further down in the Holt decision, I believe on page 5, the court makes a distinction. They say, quote, unlike situations and cases involving cease and desist orders or approvals and denials of applications, we are left to speculate the legal effects of the letter. I'll repeat, unlike cases involving approval or denial of applications. He made an application. It was denied. This rises above the mere opinion letter that's discussed in that Holt case. So the Holt case, in my opinion, does not apply to approvals or denials of applications. The next argument he makes is that I don't have the authority to act on his application. Therefore, there hasn't been a decision on his application. He refers to his letter of March 22nd, in which he points that out. What did we do? We raised that issue with this commission. And on April 10th, you discussed it. And that's a fact that Mr. Sakonchik is also aware of. He references the minutes. And he quotes, inaccurately, but he quotes, Mr. Wendt was formally authorized to enforce the regulations and to supervise the zoning enforcement officer and to direct the zoning enforcement officer to sign the letter. And since that wasn't done, no decision was made. Well, not only does that not make sense, that's not what you said. In his own exhibit, I'll quote it correctly. What you said was, it has been and continues to be the opinion and understanding of this commission that the planning director and the assistant planning director who supervise the zoning enforcement officer also have power to enforce the regulations. He acknowledges receipt of the letter of denial. He acknowledges he's aware that you made that statement on the record, and he has taken no appeal to the Zoning Board of Appeals. I, too, will refer to Robert Fuller's Land Use Law and Practice, and that's the second exhibit I gave you. And I'll quote from page 168. Section 8-6A and 8-7 of the Connecticut General Statutes allow the Zoning Board of Appeals to review decisions of zoning enforcement officer or official exercising the function of enforcing the zoning regulations where there is a claim of error in any order, requirement, or decision of that official or agency. An appeal to the board may originate from any order, requirement, or decision of the zoning enforcement officer or equivalent official in refusing to issue a zoning permit or certificate of zoning compliance. And that's exactly what happened here. I know that not only from the words in that book, but I've been doing this for quite some time, and I've been involved in quite a bit of litigation dealing with decisions that I've either made or not made. And at no time has a court ever ruled that I do not have the authority to approve or deny a zoning compliance application. It would have been a unique defense, to say the least, if that were the case. Page 169 in Fuller, Section 8-7 of the statutes provide that an appeal may be taken to the ZBA within the time prescribed by rules adopted by a ZBA, but if no such rule, within 30 days. This applies to an applicant that had actual notice of a decision. And I'll quote, an appeal taken to the ZBA more than 30 days after the challenged order is too late and the board has no subject matter jurisdiction over it. So Mr. Sakonchik has had two opportunities to appeal to the ZBA. After my letter of December 9th, 2011, depending on how that might fall with the Holt decision, and certainly after my denial of his application for certificate of zoning compliance on March 19th. He did not. So he therefore cannot stand here now and say he disagrees with that decision. Instead, he claims that no action has been taken on this application for certificate of zoning compliance, therefore it's approved. That would require a mandamus action before the court, which hasn't happened. It's simply not the case. Otherwise, we wouldn't even be here tonight. For if you recall from his first application, he stated he would rather be building a single-family dwelling on the property rather than making an affordable housing application. So if that were in fact the case, we wouldn't be here. So where does that leave us? Brings me back to my staff comments that are already in this file that have been referenced, dated August 21st. This property needs to be dealt with as a whole, not as two separate non-conforming parcels. In this modified application, does not do that, nor does his proposed zoning regulation address that appropriately. Thank you.
Thank you, Mr. Wendt. Does anyone have any questions of our staff? Mr. Wendt?
Just have one
Commissioner
question.
Barrett?
Mr. Wendt, just to clarify, actually, it's clear in your letter, I just want you to state it on the record, that your letter of December 9th, which was your first notification to Mr. Sykonchik in writing that these were not two separate parcels and that did not comply. You also referenced that previous discussion you'd had with him occurred to November 16th. That was the date which he purchased the property. Is that correct?
That's correct.
So you actually had talked to him before he purchased it and advised him that they were two separate parcels and would require a variance from the Zoning Board of Appeals before he purchased the property.
That's correct.
Thank you.
Thank you, Commissioner Barrett. Anything further from any other commissioners? Thank you, Mr. Wendt. At this time, we'll go to the public. Is there any member of the public who wishes to address the commission on this application? If so, I'll just ask you to come up one at a time to the microphone. Use the microphone, please. You should identify your name and your address, and don't be nervous.
Hello, my name is Lucas Thomas. I live at 1230 Merritt Street. It's diagonally from the property. It's on the corner of Merritt and Brookridge. I'm also a real estate attorney. If you recall, the last time I was here, I gave some arguments. You guys asked me questions. Feel free to do so again if you'd like to. I'm also here with a large group of my neighbors, and my neighbors have been very organized, very helpful. They're going to give you some information as well. I will do my best to discuss some of the legal aspects of this and set up what you'll hear subsequent to my comments from my neighbors.
Mr. Thomas, could you just bring the mic a little closer to you, please?
Yes.
Or just aim it a little bit so everyone can hear you. Thank you.
Okay. I'd like to start. I'd like to thank Jim there for his comments because they are perfect in allowing me to segue into where I'd like to begin. This idea of merger, it's very important. As you started this meeting, Mr. Chairman, you had advised the crowd, the public, that it's an 830G application and that there's a statute involved from the state that has certain requirements for an 830G application. I'd like to state from the beginning, this application is incomplete and it should not be looked at as an 830G application. The first purpose, the reason for that, is this merger issue. When we started this application the first time, when Mr. Sykonchik started this application the first time, there were two lots, an existing house, and then he was going to build something on the separate lot. In this modified application, this other house, disappeared. It's not there. Now we have 3 units in a 0.11 of an acre lot. It's not a modified application. It's a new application that he's trying to segue into having it be approved by you guys. And he shouldn't be able to do that because if you consider all 4 units, it's still under the 30% that it's required to be part of a 830G application. 4 units, one of them is identified as an affordable unit, 25%, it will not fly, just from that on its own. Now, we still have this issue of a traffic safety study. At the conclusion of the last application, the original application, it's my understanding that the board did not accept his comments as competent expert testimony. In this modified application, he's listed a document, or part of this application, a document that is entitled Traffic Study. It's signed by him. He's testifying to his own application as an expert. I still think he hasn't laid any groundwork to list himself as an expert. And I would also state that because of that, you should disregard that document as well. That also makes this application incomplete because in the zoning regulations that the town of Fairfield has, there's a section 2.44. That section on affordable housing requires that any applicant provide certain documents when an application is made. Those documents include a proper traffic study, drainage study, and certain other things that are in that zoning regulation. Lastly, on the issue of what he's trying to do here. Again, Mr. Wendt also said it's clear. He wanted to put one house there and sell it, market rate. He just couldn't do it. He figured out that he couldn't do it. He wouldn't be able to do it through the Zoning Board of Appeals process. So he comes in with this 830G and is trying to use this as a shoehorn to put in something there that'll make him some money. In his letter to the board, when he filed this 830G application, this modified 830G application, he lists a case that is Cohen versus Ledyard. This case is, at least he's stating, is the reason why he'll be able to use one unit, to build one unit there. It's one unit. He's trying to build one unit, an affordable unit, when our regulations, or Town of Fairfield's regulations, allow him to do that under the existing regulations, one unit. The first application and this now modified application still only give him one unit. And if the regulations allow him to build one unit, he should be able to do it under the existing regulations. I'd like to quote something from the Cohen case, and then I'll also submit it for the record. I can give you a little background on the Cohen versus Ledyard case. An individual tried to put a three-family unit on 1 acre, not on 0.11 of an acre. So we have this individual who, in the Cohen case, goes to all the appropriate boards before he submits his application and basically gets approvals. The property in question in Cohen is in a coastal zone. So there's certain state statutes that affect properties that are in the coastal zone. The zoning board there denied it for reasons of it might not fit with the water, it might have an environmental impact. However, he had already gotten approvals, so that's the reason why the court overturned that case. It wasn't anything that the zoning board could discuss, the zoning commission could discuss. We already got approvals. And the judge in this case, and I'm going to quote from the 7th page that I have here. The difficulty in this case, however, is that the plaintiff's proposal provides for only one affordable housing unit and thus does little to address the need for affordable housing in Ledyard. And it's the same thing here. This application only produces one unit. It does nothing for the affordable housing issue that Fairfield is in. Along with this case, there's going to be a few other cases that I'll be discussing, and I also have petitions that my neighbors had put together. I have 308 names signed here, and I'd be submitting those at the end of my presentation. A lot of the issues that are the same as in the previous application. So I'll be brief on some of the topics because they're already in the record. I had already provided copies of the deeds for the Larsons. The Larsons were the previous owners of the property. And those show this merger concept. And as discussed, there's a porch that goes over. There's deeds that show one description, one legal description, instead of two legal descriptions. And as we get to today's reality, Mr. Sakonchek had requested that the deeds be sold, or that the property be sold in two separate deeds, one to him and one to his son. While it's possible to do so, there are ramifications in doing that. One of them is you don't have any easements. You don't have any way to discuss what would happen in the future when you have a pool on one side, a porch on the other side. It was really a big plan to get himself to build a unit there. It wasn't for purposes of owning property for his son to live in or anything along those lines. As of actually last week, we've realized that the home isn't for his son. There are renters there. And now there are cars that are parked on the street, and there'll be a neighbor of mine that will be discussing that in more detail. Again, with the zoning regulations, he's modified it to where there's new language. There's a zoning application for new zone change in here. I know it's only three or four lines, but it could have the same potential effect as the previous zone application, because you have a possibility of thousands of properties that could be affected by this new zone regulation. And I'd like to point out, because of that, when it's a zone change and a zone regulation, you're kind of wearing a different hat. You're wearing your legislative hat. And when you wear a legislative hat and you make a decision based on legislation, the courts will look at what you do a little bit differently than if you're making a decision based on an administrative role. And I'd like to make that clear to you, that the legislative role that you have is a role that is based on public policy. We have a comprehensive plan. If this zone were to go into effect, it could possibly affect not just this property, but thousands of properties, hundreds of properties across the town. Well, if you find that it's not a defective application, then I'd like to go into some of the issues why it still should be denied based on the health and safety concerns that this application or this project will bring about. The first one is, based on his own language about what he's trying to do here, it is clear that he's trying to do a spot zoning, and he's trying to just build whatever he can on that lot, and that would clearly show that it's out of harmony with the comprehensive plan. Again, it's just, at one point in the beginning, it was just 2 units in this little lot. Now it's 3 units and 2 separate structures on this little 0.1 of an acre. Merger, again, is something that we discussed. And I'd like to also discuss how density might be the biggest issue that we have now based on these 3 units in this area. Currently, under this zoning regulations, density based on also the neighborhood would be at 4 to 6 units per acre in this neighborhood. If those units are built, the density that would be there would be 24 units per acre, because that's 0.11 of an acre there. And that, in and of itself, should be an issue when it comes to health and safety based on traffic, runoff, storm runoff, sewer, and water. All of these issues are just compounded by being 24 units in density per acre. Traffic safety has been found by the courts to be a substantial public interest, where you need to decide if it'll harm the health and safety of the community, of the residents of the area. Again, his traffic study is incomplete. There's no traffic count. There's no sightline distances. There's nothing there. And again, you'll hear from some of the neighbors that'll discuss the traffic count, the parking, the children, the bus stops, and most of all, actually, it happened on the corner of Merritt and Brookridge, which is less than 50 feet away. There was an accident, and the child was hit by a car. And having 3 more units there would just intensify the density of the people in that area. And the way the streets are set up and the way the houses are, there's too much overflow in the streets that would affect neighbors, children in the street, and also cars just coming through. At some point, if you have cars parked on either side, it's, you just can't get through, just can't get through. Now, also part of this issue of incomplete application is that the homes being built there will, well, if they were to be built there, would also impact the soil, the way the earth is, and the way the water would run off. And many of the homes in this neighborhood already have a flooding problem. Many of the homes have sump pumps, and by doing these putting these homes in under this application, it would just intensify the neighboring properties and the problems that they have already with their basements, with the water that comes in after, whether it's rain or melt from the snow. I'm not sure what Mr. Sakonchek has submitted to the board since the last meeting we were here. However, one of the concerns that I have, he discussed connecting these 3 units to the existing home's rain spouts. I wasn't quite sure what that was about, but if that's the case, I don't think the town would allow him to do that. And I'd like to also beseech the commission here to not forget about his previous application. He filed this modified application with certain statements in the application that state that this is his new application, that this is the complete application, and ignore what I said before, what I filed before. It's in his letter of July 7th, 2012, and it's on the second page. It says, "Note that this modified application is complete and contains all the contents of our current application. For clarity, previously submitted application materials should be used for historical reference only and not be considered part of this modified application package." You cannot do that. The statute clearly says you cannot do that. And Mr. Sakonchek was nice enough to print the entire statute in this letter. And I'd like to point to maybe the 4th or 5th line down, where it says, on again, July 7, 2012 letter, under the statute, section 830G, the applicant may, within a period for filing an appeal of the decision, submit to the commission a proposed modification of its proposal responding to some or all of the objections, restrictions articulated by the commission. That's seemingly what he's done here. However, what he clearly has tried to make a point in his letter, and that I'm trying to make a point with you, is that which shall be treated as an amendment to the original proposal. This is not any response to the original proposal. This is a brand new proposal that he's trying to put in front of you as a modified proposal. And it's not something that you should take as seriously, quite honestly. It's just another way for him to try to put more marketable units on, but still keeping one affordable unit. So ultimately, our regulations allow him to put one unit there right now. He can go down, build something, and he'll get approval for one affordable unit there now. His first application had one structure with 2 units on it with one affordable unit there, and now he's got 3 structures, or 3 units, 2 structures. It's still one affordable unit. It does nothing to help the town in its affordable housing issue. I'd like to also make a couple of comments from the last hearing. Commissioner Kennelly, you had asked Mr. Sakonchek specifically certain questions. One is this your traffic study? Is this what you're proposing to be your traffic study? And he was clear in saying, yes, this is my traffic study, the way it was presented. Also, various questions were asked by this commission. Mr. Sakonchik was unable to answer those questions. One of the questions was, what would you, if this were built, what will you do with these units? He was unable to answer that question. My concern is, I'm not sure if it's even possible, but it's odd to have two structures on this one lot. Is it possible for him to somehow in the future come and subdivide again? Or I have no idea why that would be there. If you're going to build something as a developer, if you recall in the first application, I had mentioned about it happened up in Monroe and some other towns. A developer goes in, usually buys a farm or something along those lines, has 100 units built, and puts aside 30 of them as affordable housing. That's fine. That's kind of what this was set up for. Or in the city of Bridgeport or Stratford, there might be a high-rise that's put on an area, and certain portions of that 30 or more percent of it is set aside as affordable housing. But they're more in line with what this statute is all about. This is a little off, and I'm not sure why. I haven't heard an answer of why there should be a need to have really 4 units, 3 separate structures on a quarter of an acre, or a little less than 10,000 square feet. It just doesn't make sense. And again, some of the cases that I'm going to be submitting to you, one is Majeski versus Bell, and Swaney versus Fairfield Zoning Board of Appeal discusses the merger issue, which, along with Iannucci, is great to point out how merger is the concept of merger and how the intent of the landowner is important in establishing the merger. I think that is key here. Once the merger is set up, then it's going to be key in how this application should be handled. The Avalon Bay versus Stratford Zoning Commission discusses the importance of traffic, off-site traffic, and how that affects the zoning board's decision if it finds that there's a health and safety issue. And in this case, we have this traffic that will be discussed even further because of the distance in the street, the width and the distance where this property will be, if I can just point it out. From the corner of Merritt, I'm sorry, from the corner of...
No, we can't see the board. The board.
You have Brookridge here, Homelands here, Merritt, I would say, would be over here. This street here, Brookridge, we have cars parked here. There's just a density here of the cars, of the people. If all of these units are here, plus this one, just this unit now, being rented now, we have 2 cars here, 1 car there, and 1 car here. All of this is just from 1 unit. You have 3 more units. The parking, again, this doesn't show anything about parking. It doesn't give us any information. It's a hazard between the cars coming out, if there are cars parked here, between Merritt Street coming down or coming down Brookridge from any of the sides of Homeland Street, Homeland and Brookridge Avenue. There are also stop signs there. There's those stop signs, there are regulations and enforce, which some of my neighbors were discussing regarding how far away you can park from a corner and from a stop sign. That cuts down on the ability of cars to be parked there. So where will all these cars be? It'll be a disaster when one of these kids, because we all have kids in the neighborhood, one of our kids are going to get hurt, and I just don't want that to happen.
She appreciates it. Kristen is on the fence, but she's going to talk about it. If she does, it's going to be very brief, so I think you're okay. Okay, thank you.
I'd like to submit these cases and the petitions for the record, and I'll let some of my neighbors discuss much more in depth. Each one of them has issues that will deal with the health and safety, between traffic, between runoff, water in basements, fire issues, and so on. Thank you.
Thank you, Mr. Thomas. You can pass the exhibits around, starting with Commissioner Neely, and we'll just take a look at them and get them over to the staff. Thank you. Sir, come on up, sir.
Good evening. My name is Vincent Mayola. My wife and I live at 141 Homeland Street on a 9,375-foot lot, approximately 200 feet from Mr. Sakonchik's property. Health, safety, comfort, welfare, and the character of a community, liberties, all Fairfield and state residents must be offered and provided. Mr. Sakonchik's modified site plan for 206 Homeland Street notes a piece of land that has a side porch of another property owner penetrating his property. When including the infiltration of this side porch, this property is now less than 5,000 square feet. This new application presented by Mr. Sakonchik, 3 homes, minimum 3 families, numerous bedrooms, living rooms that can be converted to bedrooms, the real possibility of 10 to 15 people with, because of need, and in addition to no nearby public transportation, 7 to 10 vehicles, maybe even a boat, motorcycle, 2 to 5 pet animals, all trying to navigate this small space, living and congregating on this piece of land less than 5,000 square feet. Mr. Sakonchik's site plan 211-067-62 shows 5 driveways in this section of Brookridge Avenue. I believe this fact is important because of the real potential of the increase in the number of vehicles in this small area, combined with the motor vehicle law that prohibits vehicles from blocking driveways, combined with the motor vehicle law that requires vehicles parked no closer than 25 feet from the stop sign, the 2 stop signs in that area, combined with the motor vehicle law that requires vehicles parked no closer than 25 feet from each of the 2 corners without the stop sign, combined with the problems shared driveways present, will definitely require a multitude of cars, not only to park in front of this project, but also wherever legal parking space remains on both sides of this area of Brookridge Avenue. Also, please note, the 2 stop signs in this area are set back 18 feet from the corner, thus creating less parking space in this area. As you can see, a clear indication of threatening, dangerous, undue safety condition will definitely exist. Of course, when visitors to these 3 homes are added to this equation, surrounding streets and resident safety will also be affected. These occurrences in this area that are free of sidewalks will most certainly increase the likelihood of causing physical danger not only to our children, who will have to find a way to avoid these parked cars, and at the same time pay close attention to the vehicles backing out of these 2 driveways when walking to, getting on and off their school bus, but also for their parents and grandparents who often accompany these children to this area. This area has already experienced increased safety traffic parking problems on Homeland Street after Mr. Sakonchik's son recently rented that house at 214 Homeland Street This is the same house that Mr. Sakonchek's son told neighbors that he and his wife were moving into and looking forward to raising a family in our neighborhood. These new renters require 3 automobiles and a truck in their daily lives. Of course, the majority of these vehicles are now parking on the street. Also of concern with these many vehicles that will eventually be parking on both sides of this section of Brookridge Avenue, often as much as 2 feet from the curb, is the town's liability when they're 10-foot wide snowplow trucks who will have very little room to maneuver their trucks in this area during and after snowstorms is protected to ensure a collision of personal injuries do not occur with the town's trucks, their drivers, and the parked vehicles. Another serious neighborhood health concern for this real potential of numerous residents on this less than 5,000 square foot property is the real health issue that will arise from the amount of trash generated. The animal droppings, the odor, and the assurance all will be properly contained, so not to affect nearby neighbors and not to attract a variety of animals to this less than 5,000 square foot area. It also must be noted there will be a definite increase in noise that will be produced by the many residents and the pet animals from this multifamily less than 5,000 square foot area. So it must be asked, what consequences will the neighbors suffer under an absentee landlord situation with this 3-family complex that is proposed to be built on this less than 5,000 square foot lot? Without a doubt, this highly concentrated application will have a deep, harmful, negative effect on the safety, health, comfort, welfare, and character of an established A-zone community. We must remember, when Mr. Sakonchek was asked by a member of this commission at his last application hearing, "Are you planning to live in this area?" he quickly answered no. Mr. Sakonchek clearly enjoys the Cheshire, Connecticut area because he and now his son have no plans to remain in this area to see the decay of our neighborhood and the hundreds of neighborhoods throughout our great town of Fairfield, Connecticut, if this application is approved. Mr. Sakonchek's remarks comparing the streets where our children play, where our elderly walk their dogs, and where our neighbors chat, to a Stop and Shop parking lot, to his comment that a detailed traffic study is not warranted because it really doesn't matter in this neighborhood, to his egotistical directive that he will have no problem at all acquiring variances for this project from planning and zoning, to his comment that a detailed drainage plan is not required, although it is a fact that many homes in this area, including his son's home next to this lot, require sump pumps to keep their basements from flooding during periods of rainfall and/or melting snow. Combined with his comment that these two structures, 3-family home layout on a lot that is less than 5,000 square feet, will blend in with nearby homes and property. I find these remarks reprehensible, condescending, and erroneous. It must be mentioned at this point, according to the Fairfield, Connecticut Home Appraisals website, there are a minimum of 35 homes within 500 feet of Mr. Sakonchek's lot that has only one home on a minimum 9,370 foot square lot that is required in an A-zone. Several of these properties are in excess of this minimum A-zone requirement. And just for a sketch, very quickly, I can leave it here. The red stars are all the houses that exceed 9,365 feet. I would also like to mention at this point Mr. Sakonchek's comment that our good neighbor, Mr. Larson, who owned Mr. Sakonchik's property before he passed away, purposely built the in-ground swimming pool on this property some 25, 26 years ago in this specific location so a home could be built where the pool is now located. It is also baseless. I have for the record a signed brief letter to the commission from David Larson, the son of Mr. Larson, which states, I'd like to read the letter? Sure. Is that okay? To the Fairfield Planning and Zoning Commission from David Larson, dated 9/4/2012. Please be advised, when my parents built the in-ground swimming pool located next to the home I grew up at 214 Homeland Street, it was built for the pleasure of my parents, my sister, myself, and our friends. I'm sure some longtime Homeland Street and surrounding residents can attest my father enjoyed that pool and property right up to the day he took sick. My parents never mentioned to me their desire to ever build a house in the area now occupied by the in-ground swimming pool. David Larson also mentioned to me that he became very curious at why, only a few weeks before the closing, the Sakonchiks insisted the sale of the home be kept separate from the sale of the less than 5,000 square foot lot. The original sale package for the sale was for the home and the side lot together. Mr. Sakonchik, that has spoken close to 3 hours over the last two public hearings, had made these and similar flawed comments, would also like this commission, our town, and our neighborhood to believe there are no safety, health, welfare, comfort, or character of the community issues with this application. We come again before this commission not only to state our objection to this new aggressive application, we are also here to speak for the children of our neighbors whose safety and welfare we must always protect, and have naturally no idea what 830G indicates. But if this application is approved, they, their parents, all of us, including the entire town of Fairfield, Connecticut, will forever feel its negative, harmful effects. Like myself, we also speak for our area's elderly residents who would like to be here tonight to state their objections to this hazardous application. This group of senior citizens has petitioned their group to be mentioned at tonight's meeting. We fully understand Mr. Sakonchik's total disregard for Fairfield Master Plan. We fully understand his total disregard for our zoning laws. And we fully understand his total disregard for our neighborhood. As we all know, and as he stated, his only goal is financial gain under what we know is the pretense of 830G. We all understand his commitment to profit by any means. But 830G does not give him the right to destroy our quality of life. 830G does not give him the right to put our children, our elderly, and all our residents' safety and health in jeopardy with this precarious application. 830G does not give him the right to diminish the character of our community. 830G does not give him these liberties. 830G was never intended to violate the safety, health, comfort of hundreds in our neighborhood and thousands in our town to financially assist one self-serving developer. 830G was never intended to have developers dictate to our town and now to our state where and how new housing development will be constructed. 830G was never intended to have developers threaten our town, its communities, and our state with 830G every time their building applications are denied that were based on established rules, regulations, sound judgments from this commission and all the hardworking commissions that preceded you. New development in any neighborhood should be at a minimum, preserve the character of that community or make that neighborhood better. Never, as this application is presented, should new development have all the elements to decline and deflate a great neighborhood. As a neighborhood senior citizen recently said to me, once you lose the character and charm of a community, it is gone forever. We have walked our neighborhood in the heat, in the rain, during the day, sometimes at night, to present you with over 300 petition signatures against this application. This tireless effort by dedicated, caring members of our Fairfield neighborhood was not offset by one positive reaction for this application. As we have stated many times, our opposition is not against affordable housing in Fairfield. Our opposition is against the interpretation and how and where the application is applied. By personally attending public meetings, I also know the Fairfield Affordable Housing Committee is working very hard with the Fairfield Housing Authority, HUD, the Fairfield Economic Development Agency, and the Fairfield Planning and Zoning Department to highlight sites that will be set aside for a good number of units, good number of quality units, affordable housing in Fairfield. Two prime examples of the town's affordable housing group effort is supporting Fairfield's Planning and Zoning's overlay zone in the Commerce Drive area, which will allow for residential development near the new train station that would require 10% of all new housing units to be set aside as affordable. And also, our town agencies working closely with the Fairfield Housing Authority to building over 38 new affordable housing units for all ages at the Pine Tree Complex in Fairfield. As we all know, this commission alone has a difficult responsibility for guiding the growth of all communities in Fairfield with due respect and regard to the public safety, health, and welfare, and at the same time stabilize or improve the character of these communities. We believe one of the most important questions this commission has to ask themselves: do the basic liberties of safety, health, welfare, character of a community that will affect and impact hundreds of residents in our neighborhood and thousands of residents throughout our town outweigh the need for 3 homes, which includes 1 affordable housing unit on a lot that is less than 5,000 square feet? Our neighborhood, our town believe the answer, without question, is yes, they do. In conclusion, it is with this presentation, with these thoughts, and with these beliefs, and also in the knowledge that this commission has the opportunity to prevent a safety health tragedy that will affect not only our children, but all our residents in our neighborhood. We ask this commission to reject this application in whole. Thank you so much for your attention.
Mr. Maiolo, are you going to submit to us the, folks, please get a hold of the applause. We have to keep moving tonight. We have to get this finished. Mr. Maiolo, are you going to submit the drawing with the red dots that you held up, as well as the Larson letter as well?
Yes.
Okay, if you just give those to staff so we can have those as part of the record, please. I'm just right over there. And they'll put it into the record. Thank you.
Another presentation.
I'll take a break at
I'll take a break at 9:30, Doug.
Says you be brief, is that what he said? He says be brief.
Hi. My name is Art Rotelli. I live at 1280 Merritt Street, and I wanted to wrap some context around Mr. Seconchek's proposed site plan, because I don't think his pretty drawings over there tell the complete story. So for the record, I sketched a somewhat scale rendering of his proposed crowded development into an overhead view. And it's titled Sakonchik Opportunity Zone for the record. Thanks to Mr. Novi for that name. 2 weeks ago, he mentioned something about this fitting into the neighborhood. I think it looks a bit more like a sore thumb. First, there's a concerning trend happening here in Fairfield that we need to protect ourselves against, and our representatives need to address on our behalf at the state level. We have developers threatening 830G on the town when they don't get their way. It's putting town residents in horrendous battles to protect the safety and character of the neighborhoods they've invested their lives in. And this law in its current form hamstrings the town from protecting us, its residents. And yet this seems to continue all around the state. And the advice we receive from one of our RTM members to get a lawyer is the advice we're owed by a town who clearly doesn't want what Mr. Sakonchik is selling. And it's not the protection we're owed as tax-paying town residents. And I state that the town doesn't want this with a good bit of certainty, and I base it on the feedback I've received from multiple sources with official responsibilities from the relating to the town's focus on the promotion of affordable housing. The Greater Bridgeport Regional Council noted there were better alternatives to achieve affordable housing, such as in-law accessory apartments, which would not affect the neighborhood and would not have a negative regional impact like his proposal would. The GBRC speaks for the state as it was designated by the Office of Policy and Management, and pursuant to Section 16A-4A of Connecticut's general statutes, the OPM is responsible for the coordination of regional and state planning. So really the state of Connecticut has already weighed in on this, and they think it's a bad idea. The town's Plan and Zoning Department has the belief that the GBRC's negative ruling on Sakonchik's original zone amendment application still applies to this modified proposal. And I think that's a fair sign that Plan and Zoning isn't eager to pursue Mr. Sakonchik's plans. I reached out to Mark Barnhart for the official position from both the town's Department of Community and Economic Development and the Affordable Housing Commission. Mr. Barnhart stated that neither his department nor the Affordable Housing Commission supported Mr. Sakonchik's application. We reached out to several elected officials in Fairfield. We haven't found a single one of them who stated support for Mr. Sakonchik's application. We reached out to our neighbors in neighboring streets. They don't support Mr. Sakonchik's application. No one supports it. We haven't found anybody but the Sakonchiks who want it. This modified application is even more destructive than his original. Just look at this. Is this what we want popping up all over Fairfield? And this is what he's proposing. And we can't let this happen. I read through Mr. Sakonchik's response to reasons of denial letter, and I learned one thing. He didn't agree with you guys. He didn't provide any more than editorial in his responses, so truly there's been a continued failure to provide adequate traffic study data. I don't believe he's given you any reason to treat this modified application with any more favorability than his original, and in fact, I think it's quite the contrary. He's actually managed to make this modified proposal less safe. He just rented his existing house, like you heard, and there are multiple cars parked on the street, lining up past where the proposed development would be. And oddly enough, he stated in his modified application that his son Brian lives at 214 Homeland, and yet it's rented out. That's interesting, and it's not a real good indication that they'll care about the safety impact of the neighborhood. And now he's telling us he might like to sell each unit individually. So now we're reducing the lot sizes down to 1,600 square feet, potentially. And I'm curious to know how many people that would add to our town if others followed suit. This commission made clear that in his proposal, no additional units of affordable housing can or will be built than otherwise could under existing regulations. And I think this commission more than satisfied an obligation of suggesting reasonable changes in order to minimize his harmful plans. But he comes back with this, all of this for one unit of affordable housing, and something he could have already done under existing regulations and what was suggested by the GBRC. If Mr. Sakonchik seems to think that it isn't financially beneficial for him to follow existing regulations and still have one affordable unit, then maybe his motive to provide affordable housing for Fairfield isn't as honorable as he'd like it to sound. And truthfully, that should be his problem and not ours. I ask that you deny Mr. Sakonchik's application and stop him from his destructive plans for our town. Thank you.
Thank you, Mr. Rottelli. Can we keep that for the record, that drawing?
Yeah, I have copies. I can.
You have a copy? Okay.
Yep.
You just give them over to the staff then. Thank you.
Good evening. For the record, my name is Kim Fawcett. I am a state representative for the town of Fairfield. I represent the 133rd District. I live at 234 Collingwood Avenue, but this application is a community not far from me, and it is entirely within my district. When in the legislature, when we create state policies, it's a long process. We have debates and committee meetings and group discussions and votes. And this process is in place because we want to make sure that the laws that we're creating are good ones and that the intended purpose, the goal of the law is being achieved. But I would say often, if not always, there are unintended consequences, unforeseen consequences when policy goals are trying to be achieved. And the policy goal behind 830G, it's a good one, it's an admirable one, but it's flawed, and it's troubling because the flaws are incredibly far-reaching. And what we're seeing across the state is developers with greedy motives who are proposing inappropriate projects that do not fit within communities but do squeeze profit out of every inch of the land and skirt planning and zoning regulations. These projects are actually not just popping up here, they're popping up all over Connecticut, and locally we're seeing them in Darien, Westport, Milford, Orange, and Ridgefield. I want the members of this commission to know, and the members of the community, to know that changes are being discussed and debated in the state legislature, and support to amend this legislation is growing and has grown rapidly in the past 18 months because these applications have grown rapidly in our communities. And builders also need to be put on notice that their actions are not going to be allowed to continue that much longer. But tonight, because of the 830G statute, I can only comment on how this application is a threat to the health or the safety of this community or to our town. And actually, I think it's the very nature of the oversized, inappropriate project that poses the health and safety threat. The on-street parking that will be required because of the multiple units is in a community where this type of parking isn't regular, in a place where there are bus stops and children play and people walk their pets and visit with their neighbors. The project is huge and tall and will block line of sight and pose yet another threat to the children that live in this community. And the fact, to me, that there is no valid traffic study by a third-party, unbiased firm is simply unacceptable and seems, out of the gate, just grounds enough to deny the application at this juncture. You know, laws within our system of democracy, they're written with this express understanding that they can and will be changed as times changed and as we recognize specifically what the flaws are in how they were written. What's amazing about our system is that we can organize as a community and we can speak out and we can work to amend laws so that they are better in the future. And the neighbors in Fairfield, they've grown a huge base of support, and they are joining a movement that is growing in Connecticut to amend the state statute. We are going to see changes to the 830G statute. But homes, the projects that you approve at your commission meetings, they become near permanent fixtures in our communities, and they're not easily undone. You have several justified reasons to deny this application this evening. Technical ones, health and safety ones, many more health and safety ones that will be pointed out to you in the next 3 hours, couple hours. And I just urge you to take it slow, deny this application, and give the process a chance to right itself. Give the state legislature a time to make the changes to this law that need to be made so that we can bring affordable housing to Connecticut in the right way. Thank you.
Thank you.
Hi. My name is Marcy Spolier. This is John Spolier. We live at 110 Brookridge Avenue. I'm going to speak first. We moved in about 2 years ago, and unfortunately when we moved, Mr. Larson, the former owner of the property, had just passed away, so we were never able to meet him. Since that time, the house has remained empty until just 2 weeks ago when someone rented the property and moved in. Since we have been there, the house and the pool have been treated as one lot. The hedges and lawn have been maintained by the same person on the same day. Most times it has been a lawn care company, but sometimes it has been Brian Sakonchik, and recently as this week, it was the current renter of the house that is on that property. She was also mowing the lawn by the pool. Sprinklers used to run were set on the same timer and would go off in the rain. I remember standing at the bus stop on the corner and the sprinklers would go off and it'd be all the way down and around the property, connecting again the property as one. When the house went up for a listing, I went to it because I'm that type of person. I live across the street from there. And again, it was listed as one listing. I couldn't go into the basement because of my allergies because it was so wet, mildewy, and moldy down there, already causing a flooding problem. A fence is actually behind the hedges, and that is again on both the property that he's claiming to be separate with the pool and the house. In regards to traffic, I was concerned before the Sakonchiks brought up the idea of bringing more congestion and danger to the area. Last school year, I had the bus garage officially change the bus stop from the corner of Brookridge and Homeland due to the dangers of our kids standing on that very corner. The stop is now at my house. The hedges of that house provide increased difficulty to see around that corner already. If we had extra cars to that area, we're just asking for a kid to get swiped by a car making a turn, or the occupants of one of those new dwellings to have an accident with their car as they pull out of their driveway that is too close to the stop sign. The current owners of that house claim that the stop sign will slow people down. I disagree on many levels. As a current occupant of Brookridge Avenue and Homeland Street, I know the traffic patterns. I know that I have multiple teenagers blow by the stop signs at high speeds. While I've been standing out there with people speaking, I've tried to tell them to slow down, and I've only gotten nasty gestures. I have 20-plus years of driving experience, and I almost hit our neighbor's car the other day because it was parked in front of my driveway. It happens now. Let's see. I also know our office, living room, and dining room, we can see that corner, and people do not stop. It happens every day. They do not obey the speed limits, and they do not stop. I also know that by adding the 2 driveways and the 3 dwellings to Brookridge Avenue, he would be increasing the driveways and living quarters on that street between Merritt and Homeland by 100%. Currently, there are 3 driveways in that area, and he is going to be doubling the amount of residents. That's a 100% increase. I also witnessed him complete his traffic study on Friday, June 15th. This was after the last hearing, but prior to your zoning board turning down his initial proposal. I came home from work as a home care physical therapist to do some paperwork in my office around 2:30. And he was not conducting his study as there was no sign of him and there was no car pushed into the bushes. I watched his study. He did not sit there and count the cars, buses going by. He used his car and a boot as his official equipment to conduct the study. His boot was blocking the second driveway, and that was the extent of how official his equipment looked to me. I approximately guessed that he was there 45 minutes until he went a few blocks over and began taking pictures of the kids getting off the bus without their parents' permission. I have a picture of me from my window taking a picture of his traffic study. I unfortunately did not get the boot. I didn't see him move that until the completion of his study. He doesn't care about the safety or the people in this neighborhood. Another time I witnessed his lack of caring was when his fence was left open for 2 days straight in August. His fence that houses the pool, he doesn't lock this fence that surrounds the pool. It provides endangerment to those in the neighborhood, including animals, and it's against the law. He doesn't care that his dwellings will be so close that they'll cause a fire hazard, and he doesn't care that he'll decrease the surface area of the property, that all my neighbors downside of him should expect increased flooding. He doesn't care that when the occupants of those dwellings have an emergency, the emergency vehicles and the emergency stretchers won't be able to get into the houses. I don't even think his plan has plans for a back door because there's no room for one. He just doesn't seem to care about the neighborhood and the safety of the people. The only thing he cares about is the money. I also have a picture of his fence being left open, if it pertains, and I'll enter those into the record.
Thank you. What I'd like to talk about here is the sight lines for the traffic on Brook Ridge and Homeland. If you look at what we have here with the drawing that Art has submitted, the sight line, if you're going north on Homeland Street, gives you maybe 25 feet, not even, of sight line over to Brook Ridge, okay? That's without a car in the driveway as being stacked. Just stopping wise, if a car comes zipping down, okay, according to the James Madison University Comprehensive Study Plan, they had a ratio of speed to stopping distance, okay? According to the study, or according to this, and I think the law of physics applies the same here as it does at James Madison University, is that at 15 miles per hour, it takes 44 feet for a car to stop, okay? There's definitely less than 44 feet to be able to see at that corner if a car is coming down here, okay, and seeing a car coming to Brook Ridge. At 25 miles per hour, it's 85 feet, and at 35 miles per hour, it's 135 feet. Okay, this includes a 1.5 second reaction time, which, to be honest with you, I think is being pretty generous at this point, as most people who drive down Homeland Street are either expecting the people on Brook Ridge, coming through Brook Ridge, to stop. Okay. So definitely the speed of cars that I've seen go down Homeland is more than 15 miles per hour, and it's more around 25 miles per hour. Okay? What I'm afraid of is that with our driveway here, my son and his friends, or my daughter and her friends, come zipping out, want to make a right onto Homeland. That car that's zipping up Homeland here will not have enough time to stop. Okay, from a safety point of view. As already mentioned, we have parking issues. Again, parking on the street, that's been mentioned, as far as blocking views of other cars. Okay, so why am I so concerned about this with Brook Ridge and the stop sign here? Since our last meeting, I worked from home 3 days and watched out the office window that on August 30th from 8:45 p.m. to 8:45 a.m. to 5:45 p.m., I saw 5 people blow the stop sign right here. Okay? On August 31st, from 8:30 a.m. to 4:45 p.m., 3 people blew the stop sign. And I'm not talking rolling through, I'm talking nonstop. And on 9/6, from 8:30 a.m. to 6 p.m., 6 blowing stop signs. So there is a safety issue here that we have presently with the way people drive in the neighborhood, who come through our neighborhood. This is only going to increase the risk and the probability of an accident happening. Okay. I'll just a couple other comments based on what was said at the last meeting. Mr. Sakonchek talks about 50 feet being on Homeland and the property facing Homeland, but these structures are facing Brook Ridge. And every property between Merritt Street and Toilsome Hill that are on Brook Ridge have 100 feet. per property that faces it. Again, it's probably because we've got a short block and it's a safety issue then of crowding. There was also the example that Commissioner Leclerc you had with regard to yourself and two other commissioners owning the house or owning the houses, okay, or want to buy the houses. Who's got the affordable housing? Who doesn't? And the response that we got back was more of a shell game. And I'm still trying to figure out what shell the ball is under with that response. So if we could get a firm answer out of Mr. Sakonchek, which unit is the affordable housing unit, that would be great. As far as the easement and drainage goes, as Lucas has mentioned already, with the sale there was no official agreement for the drainage to be set up, nor was there any easement of the porch going over to the second property, Mr. Jim Sakonchek's property. And I don't believe there was one submitted in the application. So I think that right at that point we have, there's ambiguity involved with that I personally would like to see resolved before this even gets passed, which I hope it does not get passed. Thank you.
Thank you.
Good evening. My name is Elaine Thomas Davis. I live at 206 Farmington Avenue. I would like to briefly comment on Mr. Sakonchek's assertion that the sole purpose to locate Mr. Larson's in-ground swimming pool in that specific area of Mr. Larson's lot was to build a house in the future. My family and I knew the Larson family for many years, and of Mr. Larson's lot. We spent time, my parents, myself, my family, discussing the pool and the pleasure that it was given to Mr. and Mrs. Larson, their children, and their children's friends. Not once was it ever mentioned by anyone in the Larson family that in the future, the in-ground swimming pool would be dug up and replaced by a house. Furthermore, it must be noted, right up to Mr. Larson's passing away at age 81, he could be seen by neighbors, including me, keeping the grounds neat and clean and waiting in his pool. It was obvious to all that Mr. Larson loved this pool. It is my contention and my family's contention, based on our personal contact with the Larson family, a house was never considered to replace the in-ground swimming pool. Furthermore, Dave Larson knows that I'm here this evening, and he supports what I say 110%. I thank you.
Thank you. My name is Chris DeSanctis, and I live on Old Stratfield Road in Fairfield. Thank you for this opportunity to share with you my views on the application before you. I am in favor of affordable housing, but I do not believe developers should be allowed to circumvent zoning regulations and to dictate important issues like housing density by invoking Section 830G. This bad law has been on the books for 20 years, and it should have been amended long ago. I believe that 830G should be revised in the following ways. A one-year moratorium should be granted to any town that wants to create a smart growth master plan that specifies where affordable housing can be built. Local commissions like this one should have the authority to deny applications that are not consistent with the town's smart growth plan. All Connecticut towns should be given credit toward the 10% affordable housing threshold, beyond which, as we know, 830G applications may not be made, for any affordable housing that exists, but which was not built with public assistance. Only initial development applications for any property should be allowed under 830G. Secondary applications that are made after a standard application has been denied should not be allowed.
And finally, I think we all agree that there are many good sites for affordable housing in Fairfield. Homeland Street is not one of them. Thank you for listening and for your public service on this commission.
Thank you.
I promise I'll be brief. Cliff Myers, 180 Lindley Drive, Fairfield. I don't live in that community, although I have several friends here who would kill me if I didn't come up and talk, because, well, that being said, I know this area very well. It used to be part of District 6, now it's 7. I played on these streets as a kid a couple years back.
They didn't have cars then, did they?
Yes.
You mentioned District 6. For the record, you served as a representative for the town meeting for District 6.
Yeah, a while back. I'm also presently on the Fairfield Bike and Pedestrian Committee. We talk about safety and traffic all the time. I would come to these meetings and be totally frustrated by how you're sort of handcuffed by statutes or whatever. So it seems like safety is definitely something that you can put your hat on. One thing that we talk about in our committee is how to have pedestrians be safe in town, and the town has gone through a large project of trying to make more and more sidewalks to make it more amenable to pedestrians. There are no sidewalks here. The sidewalk is the street, and if this comes before you again with regard to a traffic study, I'm sure the number of cars will say it doesn't matter, it's not many, blah, blah, blah. But I would ask and hope or suggest that you ask this safety expert, a traffic person, to ask them if they believe that if you have more off-street parking, and one good thing that I can see just from this picture here is you don't see very many cars at all parked down the street. Now when you have additional cars parked on the street and pushes people out into the middle of the street, is this a safer situation than it was before? And let them tell you it is or it isn't. And secondly, I guess the other point that you can hang your hat on is other matters that may outweigh low-income housing. And again, this part of town is very democratic. We've always supported low-income housing when it came before us, when it made sense. I just think that I just lost my thought there for a second. Oh, I know what it is. Something we always talk about a master plan. If this 830G can trump the master plan, which is so intricate in what you all do, then I think that might be an issue that outweighs the approval of an application of low-income housing in any situation at this point. If you don't have a master plan that's based on local what the local people want, then I think we've just gone totally backwards. So those are the two issues. If you can hang your hat on, those are things I would hope that this commission would look into. Thank you very much.
Thank you.
Good evening. My name is Don Canetta. I live at 233 Homeland Street, a property across the street and adjacent to 214. What I'd like to do this evening is to provide you with some pictorial evidence to back up many of the comments made tonight. Just a brief validation of my own credentials regarding traffic. I've been a high school teacher and administrator for more than 40 years. And during that time, I've had supervisory and administrative responsibility for busing, automobile drop-off and pickup, staff and student parking, and parking lots. And I believe this would qualify my opinion as much of an expert on traffic as Mr. Sukanchik. By way of this pictorial evidence, I'll show that the proposed application will significantly and dangerously add street parking, which will endanger the safety of residents, most especially children. As has been mentioned recently, 214 Homeland was rented to a family. With them, this family brought 4 additional vehicles to Homeland Street. Though there is a one-car detached garage at 214 and a shared driveway with room for tandem parking, the new residents choose to park 1 car in the driveway on a regular basis and 2 to 3 cars on the street in front of the house. Extrapolating from this reality, I conclude that there's a real probability that the 3 proposed structures will add at least 3 cars each to Brookridge Avenue for a total of 9 new vehicles. 2 vehicles of each unit for a total of 6 have the probability of parking on the street, using this recent example of the new renters in 214 Homeland. Print number 1 is the typical scene. This print here is a typical scene in front of my house. In fact, I took it only a week or so ago, 2 weeks ago, as I was coming home from work and the kids were out in front playing kickball. That's often the case. If you look at the cars in the background here, this car here in the house here is 214 Homeland, and this in fact was the new occupants moving in. Print number 2 indicates a typical day of street parking since the unit was rented. That's this picture here, with 2 cars traditionally parked in the front and sometimes 3, again adding to the street parking, and this is Homeland Street. Print 3 is a view of Homeland Street on a typical day. As has been mentioned this evening, generally speaking, there are no cars parked on Brookridge Avenue. But print 4 will give us a view, and this view is looking north on Brookridge. Print 4 is looking south on Brookridge. The property in question is over on this side. And you'll see again, there are no cars parked at all on Brookridge Avenue. Print 5 gives us a view with what the street might look like once these units, or if these units were ever built. You'll see that there's 3 to 4 cars parked on this side, there's 3 cars parked on this side. The space beyond the stop sign here is where the driveway would be proposed to be, and you can see from this line that the stop sign is very close to where that driveway would end. The result being that you have a dangerous situation. You have children constantly playing on this street, running out in between parked cars. As has been mentioned, it's going to double the number of driveways on the street, which means that it's going to be dangerous backing out and the potential for some terrible accidents. The addition of 6 cars, which I explained would be the probable number of additional cars parked on the street should these units go forward, would create blind spots pulling out of driveways and dangerous conditions for many of the children living on Homeland and Brookridge. Notice there are cars on both sides of the street, and it's very dangerous for children who often cross the street or play in it. Print number 6 is a view looking south, south with cars parked on both sides, again a dangerous situation for children. Moreover, cars parked so close to the proposed driveways would limit the field of vision for cars exiting the driveways. And finally, print 7 depicts a typical evening on Brookridge Avenue, but with the cars in place, and you can see that there are children riding scooters and bikes and playing very healthy interactive games on this street, obviously a dangerous situation. I offer, do we deny our children the opportunity for this safe and active recreation because an unscrupulous developer wishes to turn a profit at the expense of our very real and serious public concerns? That would be a travesty and contrary to every value we hold dear regarding family, community, and the wellness of our children. Mr. Mialo raised very serious concerns regarding the location of the driveways in proximity to the corner of Homeland and Brookridge and the stop sign on the corner. I completely reject Mrs. Sakonchik's line of sight opinions as generalizations and erroneous. Cars parked as they would be seriously restrict line of sight pulling out of the driveway, and proximity to the corner creates a dangerous lack of line of sight for cars turning north from Homeland onto Brookridge. I make that turn many times during the week, and I can attest that cars parked as indicated in the photo will undoubtedly create a dangerous line of sight and turning challenge if someone were to be pulling out of the proposed double driveway. Not to mention the serious challenge to the school bus driver who makes that turn daily. As mentioned earlier, the number of driveways on this short section of Brook Ridge will be doubled by this proposal. Yes, there are similar multiple driveways on Homeland. However, these driveways are owned and occupied by single families who have 2 cars generally, and also generally use their driveways, thus avoiding the kinds of dangerous scenarios I've mentioned. I also included this to mention that there are no sidewalks anywhere in this area, as you know. For the record, I'd also state that I have a sump pump in my house. All of my adjacent neighbors have sump pumps. Again, the runoff problem and drainage. In a Western New England Law Review article, Terry Tondreau, who none of us know, but we should know, or do we? Terry Tondreau is was the co-chair of the Blue Ribbon Commission that actually created this Appeals Act 830G 20 years ago. He wrote an article in the Law Review several years ago, and he said that challenges to the law, that he notes that many challenges to the law and states that the rejection of an 8-30G application must be supported by the following. 1, the decision and the reasons cited for it must be supported by sufficient evidence in the record. I believe this evening we are placing that evidence in the record. 2, it must be necessary to protect substantial public interest in health, safety, or other matters which the Commission may legally consider. I certainly believe we produced that evidence this evening. What is more important than the safety of our children, as shown tonight? 3, such public interests clearly outweigh the need for affordable housing. As has been mentioned earlier, the Fairfield Housing Authority, the Affordable Housing Group, is working diligently to provide more affordable housing. How can any percentage quota outweigh the safety of our children? Such public interest cannot be adequately protected by reasonable, number 4, such public interest cannot be adequately protected by reasonable changes to the affordable housing development. This minute piece of property doesn't give the applicant any possibility to make any kind of changes which are going to ameliorate the kinds of safety issues we're mentioning. The article goes on to state that an applicant's failure to consider the traffic, safety, or environmental impacts of its proposal have been upheld as legitimate reasons for rejecting the application. In a more generic comment, it said that making the developer the affordable housing planner, quote, eliminates the need for a state agency to make determinations. Well, that's obvious. What I say is that, true, it places the control of planning in towns and in the hands of the developer, but I say this is akin to the fox guarding the hen house. The obvious downside of relying on the developer to do affordable housing planning is that the developer's decisions about where to build will almost always be based simply on market considerations such as which land is available, its cost, etc., rather than on planning considerations such as where it is best to provide housing for low and moderate income families. Fairfield is making considerable strides in providing affordable housing as a piece of the master plan. Because of that, this proposal, I believe, should not override the need for affordable housing in this town. Our primary objection to 830G is that it gives the applicant an opportunity to force municipalities, or one primary objection is that it gives the applicant an opportunity to force municipalities to accept land use proposals that violate good planning principles, because the applicant can win an appeal regardless of the merit of its proposal. Put more incisively, an applicant can, quote, blackmail, end quote, a town into accepting its development proposal if it is not one for affordable housing by threatening to withdraw the objectionable application and resubmit an affordable housing application. The assumptions behind this allegation are that the affordable housing use of the site would be more offensive to the town than would be the use proposed, and that the town would lose an appeal of its denial of the affordable housing application. This most offensive scenario that I just described, where a developer submits a proposal that the town wants to reject for sound planning reasons. However, any expressed objection to the proposal by the commission is met by the developer's threat to reapply with an affordable housing component as a new part of the original plan. The assumption is that the town will not be able to deny the new proposal because it will lose a developer's appeal brought under 830G. Just another reason why something's got to be done to change or repeal 830G. Statistically, Mr. Tronto says this coercion scenario is the exception rather than the rule. But as we have witnessed in recent months in this particular application, this coercion scenario is exactly what this applicant is attempting to do. Clearly, this has been and is Mr. Sakonchik's intent all along. We cannot permit him to force his proposal upon this community. We cannot let that happen. Nevertheless, 830G does prevent the town from continuing to control the uses of land use in the town. Rather, it requires the town, does not prevent the town from continuing to control uses of land, in the town. Rather, it requires the town to identify sound planning concerns as the reasons for rejecting an affordable housing application. And it precludes rejections for reasons that have no basis in public health or safety. I believe that throughout this testimony this evening and in past meetings, we have presented evidence supporting the concerns for sound planning and made a very strong case for protecting public health and safety. I ask that you reject this application. Thank you.
Sir, are you submitting that drawing for the record, please?
I will, yes.
And Commissioner Wagner, did you?
Thank you. Yep.
Commissioner Wagner had a question.
In number 5, for example, you mentioned that represents what the parking would look like after the build.
Yes.
How did those cars get on the photo? Did you put them? Did you superimpose them there, or did they just happen to be parked there that day?
No, I placed them there to simulate what it would look like once the units were built.
Got it. So you took real cars, you parked them on the street.
Those are real cars. The 2 are my cars, 2 are Mr. Miolo's cars, 2 are other neighbors' cars, and we parked them to simulate what it would look like.
Got it. Thank you.
And we measured the distance so that we provided for the driveways also, which make the whole scene on that street very tight and very dangerous.
Thank you.
Thank you. Just so I can get a sense of timing this evening, how many more folks are intending to speak to the commission? Okay. What we'll do is let's take Selectman Vahey, and then we'll take a 3-minute recess.
Thank you, Mr. Chairman. Kristen McCarthy Vahey. I live at 1625 Melville Avenue, and I'm a selectman here in Fairfield. First of all, I support affordable housing in our town, and all of the many initiatives that have been addressed here in the proper way to address the issue, and I do not believe that this is the way to address affordable housing in the town. I agree that there are some much needed amendments that need to happen to 830G. However, that is not what we are able to deal with here tonight, and nor are you as commissioners. What you do have is an application before you. And I just want to talk about 2 very specific pieces of the testimony that I heard from Mr. Sakonchik last time that I was here. I was driving home from volleyball practice with my daughter last week, coming up Melville, and we were driving down the street, and she said to me, "Why do so many people park on the street when they have driveways?" And in the past 18 months or so, we've had 3 single-family homes on our street that were either formerly unoccupied or occupied by folks who were not drivers, elderly folks, that now have multiple vehicles in the street. And it has made a significant difference in terms of safety with children and senior citizens, people walking their dogs, pedestrians of all kinds, as well as vehicle traffic. Mr. Sakonchik talked last time about stacking, and his proposal would allow for that, and he demonstrated and discussed how simple that was to do, and it was something that he had done easily with his wife, and I applaud him for that. The reality is most people do not do that. Many people do not stack their cars, and they park on the street when there are multiple vehicles. It's been well demonstrated and discussed earlier. The last thing is just a simple anecdote. It's not simple, actually. It's a tragic story. When I was a young student myself in Pennsylvania, I took the bus through a neighborhood that was very similar to the Homeland Street neighborhood. And there were many cars that over time were parked out on the street. And there was a 7th grade student who ran out between 2 of those cars, and she was struck by a vehicle and killed. And that is the biggest concern here to me with this application. And for that reason, and for all the reasons that have been addressed here, I hope that you are able to validly deny this application. Thank you.
Thank you. We're now going to stand in a brief 3-minute recess, then we will reconvene. Second session, folks.
Listen, can you talk to me in the morning? Can I call you? What time is it?
We're going to reconvene. I want to continue with the public hearing so we can get this finished tonight, both public comment and Mr. Sakonchik's rebuttal. So let's keep the meeting moving. Anyone who's speaking, feel free to adopt the comments of other individuals as well. And does any other member of the public wish to address the commission? Come on up, sir.
Greetings. My name is Mark Patton. I live at 503 Valley Road, and I'm also an RTM member for District 7, which 224 Homeland Street encompasses. And I'm not here to reiterate the many amazing comments and facts that have been presented by the community. I am here, however, to read a letter by one of my constituents and the neighbor who abuts the property of 224 Homeland Street, who could not be here due to family concerns. Deborah Blanchard, her and her husband Sylvain live at 224 Homeland Street. I'm sorry, 214 Homeland Street. Dear TPZ, first let me start by apologizing that I cannot be here at this very important meeting this evening due to family issues. I know as the abutting property owners, it is important for us to be at the meetings and to take stand on this issue. I'd like to point out a few items that have happened since the last time I've spoken in front of this board. The house number 214 has now been rented to a very nice family which has 3 people. Each of those people has a car, adding 3 new cars to our neighborhood, and 4 from what I'm hearing with the truck. If Mr. Sakonchik gets his new proposal of adding a single-family home and a duplex, let's assume at the rate of 3 cars each, that would add an additional 9 cars to the neighborhood, with the possibility of even more than 9 on top of the 3 new ones in the existing home. As we have many children in our neighborhood and a bus stop right across from the proposed new houses, I would consider that a great health and safety issue for the children with all of the car fumes and the added traffic. A second point I'd like to make out is that 214 Homeland, now being rented, and our home, 224, both have sump pumps already. Each time that it rains, my sump pump goes off at a constant rate. By covering what is left of the 5,000 square foot lot, number 206, one lot away from mine, there will be no ground left for the water to seep into, causing even more flooding for me and many of my neighbors. As our neighborhood has grown with additions to current homes and patios covering what was left of land for water to seep into, my lot has now been compromised as the water flows down my driveway, and I now have a huge hole under my garage from the water damage. It has gotten so bad that my above-ground pool began to sink into the ground recently, and I was forced to remove it. I invite this board to come and take a look at the gaping hole under my garage, which will be further damaged by adding more houses next door. I ask that you take that in consideration when making your decision. Thank you, Sylvain and Deborah Blanchard.
Thank you. Thanks.
Good evening. I'm Jennifer Hochberg, 232 Churchill Road. I am also a member of the RTM representing District 7. I want to say thank you to the TPZ for all you do, and also a thank you to the residents of the Homeland Street neighborhood who have come together and organized because this issue matters a lot to them. There's been much said tonight and previously, but 2 words keep coming back to me: health and safety. Those 2 words are more important than making a profit. The decision you make, members of the TPZ, will not only affect the neighborhood, but also the town of Fairfield as a whole. Thank you.
Thank you.
Thank you, Commissioners. My name is Nick Novia. I live at 111 Farmington Avenue, exactly 1 block up, corner to corner. I'm here to make an impassioned plea for you Commissioners to deny this application. As hard as it is to go around all the parameters of 8-30G, the health, the safety, then there's a B and C that I looked at today. I really couldn't understand it because it did say other criteria, and it had something to do with the effect on the neighborhood, but I think that was more health and safety things. So, anyways, and Mr. Sakonchik's last speech when he was here, the last meeting, he did vie off the path of the character of the neighborhood and things, so I don't mind if I take a little bit of freedom there too. We'll get to health and safety. There's some of that to go around too. But the intent of the law, which we have no control over, and what our representatives are trying to do, which is the right thing, which we have no control over now anyway, certainly did not call for this type of construction. And that's what we're going to try to avoid. So I read of these communities having moratoriums now because they reach a 2% plateau. There's a thing in the statute for moratoriums, and other towns are doing that. I'm not sure what our towns are doing about it, or we can. I know what are we at, 1.7 or 1.9% of the needed affordable housing. So we're hoping that they can do that. So we appreciate Mr. DeSantis and Ms. Fawcett, telling us the things that are happening in the statewide races there. I'm hoping that Mr. Wentz's testimony about the merged lot, that's going to give you power to, and any judge to support a denial if that's what you choose to do. That's the kind of thing, that seems strong enough to me, that type of testimony. And not only that, the testimony from the past residents who talked about the merging of the lot, and testimony from neighbors who have spent time with the Larsons, the merging of the lot. I don't understand how that can be undermined. The health and safety, I'm thinking that it's a domino effect. If it happens here, it can happen. There's a lot of big lots. I have a 15,000 square foot lot. Luckily, I have a 2-car garage and parking for 4 cars. But they don't have that down there. So I want to just speak to some of the Mr. Sakonchik's uncertified testing. First of all, he had that beautiful map of the streets, and he showed you how if you came here, you would stop, and the driver was there, and if a car went this way, 15 miles an hour. And he could talk all day long like that, but it's not a certified report. I think our neighborhood's more certified to make reports like that. I'm certified. I come down the hill every day. I go faster than 15, I'm sorry to admit. I do. But one thing that he failed to talk about was, he talks about always going this way and this way. But I was looking at that map thinking about this driveway here and somebody backing out, which is probably going to happen 10 to 15 times a day, because if you want to go down to JoJo's store or to the mobile station or the Stratfield Market, God willing, if it ever comes back, you're going to be backing right into this. That's the dangerous part. That's the dangerous part of that driveway. Okay, it's close to the stop sign. I'm no traffic expert. All I know is I go down that street pretty fast, and that's not easy to see if somebody's backing out. So if somebody's backing out and somebody's coming down, you have to look at the worst case scenario. That's what it is. We have it by a boat, it's the worst case scenario. What kind of weather do you want to sail in? You want insurance, it's worst case scenario. This is the worst case scenario. So that report, you can throw that right out the window. Flooding, I went to see that sinkhole today. I stopped by Debbie and Sylvan's house. It's about this big, right at the left side frame of their garage. And it's deep. And then I looked in their backyard where the pool was. It's a big sinkhole. They're going to need to put a big truck in there and dig that all out. She said years ago when the Larsons had the property, and I believe you discussed that pipe. Where's that pipe? On the map. There was a pipe that she was talking about that went from the street down to a drain that they had built. They have the shared driveway. There's an easement on the driveway right in the middle. And that's completely useless. It doesn't, nothing to get, there's no water leading to that drain because the pipe's crushed. So Mr. Sakonchik's uncertified plumbing testimony, probably is not going to talk about that. Or Marcy Spoliers, when they looked at the house, she said it was so wet down there, she wouldn't even consider the place. That report's not going to reflect those kind of things. That's a health issue. Isn't that a health issue? That runoff? That's runoff. She's responsible for it. You know, it's her property. But that's because of the way the runoff is. The backyards run downhill. My expertise comes in the way of fire. I'm a retired fire captain, and I was a certified fire marshal from the state of Connecticut for 14 years, until recently, 2011, I retired. And I look at that property as worst case scenario as far as safety for the firemen. Let's just talk about that traffic for one thing. Now that we do have tenants in 214, there are 3 cars there all the time, sometimes 2. But when I come down from my house, I'm going all the way down, taking a left on Prospect and going out to Toilsome. When I go down to JoJo's. I have to go slow down there between it with cars on both sides. I drive a pickup truck and a Odyssey. And there's no room for 2 cars to pass, unless you have to really be careful. Now, I know that engine 3 on Jackman Ave, when there's a fire up our way, they're going to come up Eastwood, take a right on Toilsome, they're going to take a left on Brookview and take the hydrant at the corner of Windermere, and they're going to take the hydrant and they're going to go in. There's not necessarily a traffic problem there. That's where the stop sign is, and that's pretty wide open. Engine 2 is coming from Jennings. They're going to be coming up Toilsome. They're going to take a left on Prospect. They're going to take a right, and they're going to take that hydrant at that corner, and they're going to try to weave that Engine 2, which is a Big Mac rig, and they're going to try to get up there. They are not going to get in there. That's going to hamper access of fire and emergency vehicles. There's no doubt about it. That's just trucks and engines. Now, as a firefighter, I look at that gap between the porch and the house. It's 6 foot 2 inches or 6.2 feet. I'm not sure how to read that plan. I think it's 6 foot 2 inches. What it could be 6 foot 0.2, whatever 0.2 is, so a six of it.
6 foot 2
inches.
Yeah.
And then 8 foot 8.
Yeah.
Okay, so there's going to be no access in there. Really, there's minimal access for ladders, because ladders don't go straight up. You have to have there's an angle, okay? So there's not a lot of access in there. So, and I talked about radiant heat before, as far as how heat conducts, you know, convection, conduction, and radiant, which is the worst. And Mr. Sukanchik said, you know, and he was right, the house is going to be built to code, and that's what it's going to be. But looking at it again, looking at it as a fire inspector, as a fire marshal, these beehive-type buildings, I see an exit there and an exit there. I don't think Art got the exit right, because that exit is supposed to be in the rear, the side exit. According to the first plan that Mr. Sukanchik had there, you can look at the rear. It looks like the exit is here, and then the back side there, I guess it would be. Or the other side there. That's a little bit different, I think, according to that plan. The International Residential Code, which handles the code for new structures, 1 and 2 families, says that exit discharge should be 10 feet away from any property line. Now, I know 830G can subvert zoning laws, but it cannot subvert building code, and it cannot subvert fire code, correct? So that's what I'm looking at. One of the provisions in NFPA 1, as far as exit discharge, is that you have to have, let me just word it like they did, sufficiently open space to minimize smoke accumulation and toxic gases. The poor people that rented that house have no idea what's planned to go up next to them. So there is no room for any kind of, there's no room for any kind of smoke. You know, it's going to be terrible in there. It's going to be a terrible atmosphere if there's a fire. We're looking at it for the worst case scenario. Safety-wise, from a fireman's standpoint, it's not a really good situation. There's no good access for fire trucks. There's no good access for firemen. The exits are anywhere in a building. you have exit access, the actual exit and exit discharge to your public way, which is Homeland or Brook Ridge. And to get that, it's compromised here in this plan, which to me shows minimum requirements. This is saving money. He's not digging a hole, he's building up. 3.5 stories high. I don't know how it's going to be only 32 feet. That's not for me to say. Anyways.
Mr. Novi, can I ask you a question?
Yes, sir.
You spoke about the porch, the encroaching porch in the back of the property. Could one safely put a ladder up with a given space as proposed to take someone down from a second floor window in the event of a fire? Are you saying there's not enough room to safely put a ladder up to go up to that window and take someone down?
It's 6 feet, 6 feet 2 from the...
That seems pretty close to me. As you know, when I put a ladder in my house, I know 6 feet's not that...
Right, from the backside, which is flat, and I forget the formula. There's only you can only go so high where it's safe. And there's an angle to a ladder.
You can't put the ladder against the other building. You need to have space in the ladder to get on the ladder.
Right, but to put up a ladder correctly by NFPA 1, which is the document that rules all fire code, first responders, and being more adopted all parts of it now. There's I forget what the angle is, because, you know, I was a captain, I just told people what to do, and I forget, all right? I've been retired already, and I forgot. But there's an angle. I know that it's not going to be up to the second floor or above, you know.
That's my point. The ladder can't safely get then to the second floor.
It's going to be very difficult. It's going to be very difficult to put a ladder up. It's going to take more people than normal, because people are going to have to hold it. That's what's going to happen. You're going to have two people footing the ladder before some firefighter goes up the ladder. And for rescue, it's going to be very difficult. As far as getting a big tower ladder in that angle, that's going to be very tough too. It's just a very dangerous situation. So I don't know what else to say about that. I mean, I don't like it. I don't like the situation. As far as health, well, let's see. The shade on 214.
Mr. Novi, are you aware of how many firefighters are on our engines, the first responding engines in Fairfield?
2.
And the engineer. So
they can't raise a ladder because one's an engineer and one's...
The engineer has to stay with the truck, so until a second unit gets there, if a fire truck were to get there first, the pumper with the ladder...
Which that will be the case. The engine will be there first.
The men that can leave the truck, there's not enough men to leave the truck to safely put that ladder up and steady it and get upstairs to rescue someone, you're saying? If you only have 2 men, you need more than that to steady the ladder and get up, given the confinement.
Right. Fairfield runs differently than Bridgeport. They definitely have less people than we have. And at the end, we had 4 and 4. And when you're talking about search and rescue, there's no time to grab a ladder. And the engineer on the engine company, first thing he's doing is you got one guy at the hydrant and the engineer's going. So there's 2 people right there. So Fairfield, some engines may run with 3, and they don't run with an officer. So you could have engine 3 coming up, and there's one guy's at the hydrant and the other guy's at the pump. So his job is going to have to be probably go do a primary search if he can find out what to do, and wait for extra people to come to run the pump, or somebody's going to take his place. So
you don't have the manpower to put that ladder up if you're the first unit?
No way. They're not going to put a ladder up first off. The truck company's going to do that, and that's a difficult spot to put a ladder up there. I don't know, there's not one... Mr. Sukanchik said he's going to build it like the other houses. These are beehives. These look like beehives. We don't have any beehives in the neighborhood at all. And there's not one house that's even close to being that close to the other property. And I walked down and I measured them all the last time we had a meeting. And it's all way smaller than... This is way smaller than anything else in the neighborhood. You can look at it. You can tell by looking at it. These are the only 50 by 100s. There's not that many of them, really, just that one stretch of street. So everything on this side's big. Anyways, I plead with you, commissioners. You know that your legislators are behind you, and the building department's given you great evidence, I think, along with testimony of residents and the ex-owners. And I just plead, deny this. And I think we're going to win in the end no matter what, because I think that we have right on our side. And I want you to know that all of us here, we are behind you 100%. When you vote against them and we go to court, we're going to be there. Whatever we can do, we're going to be there behind you too. Thanks very much.
Thank you. final comment by any member of the public?
Hello, Ellen Jacob, RTM District 9. Just wanted to add a little support to the idea, if you need it, to the idea of a moratorium while we await the 830G to be repealed or amended. I'm just wondering if you would consider at some point seeking a moratorium on 830G applications from the State Department of Economic and Community Development. And even perhaps Mark Barnhart in our town can help. Darien was granted a 4-year stay, and Ridgefield's application, I believe, is currently under consideration. It's just a thought. I don't know if it's feasible, but I wanted to support that idea.
Thank you. I just think it would be valuable, if I could ask the Director of Planning, these questions have been raised before. Could you just take one moment briefly and explain, if you could, sort of what the situation is regarding any kind of opportunity for Fairfield to apply for a moratorium or something like that? Or what's the unit threshold or something like that? Just so people understand. I mean, what that threshold is, just to understand what you're hearing this like different towns, if you could. Yeah, what percentages are involved?
Briefly, so we can.
Just so people understand.
Yeah, very briefly, Joe Novacek, the Planning Zoning Director. There's a point kind of system that you have to go through a process that we don't reach that threshold yet. To do that, a lot of things would have to happen over and above regulatory. There would have to be some construction of actual units. That number, I don't know off the top of my head, but that would have to take place prior to us even being able to get into the threshold for requesting that. But we're looking at it, and we'll continue to take a look at that, those requirements.
Thank you. Sir?
Hi, I'm Jan Reber from 85 Beaumont Street. I don't live in the neighborhood, but I'd like to discuss Section 830G with you briefly, because I think the discussion of it hasn't talked at all about what the responsibilities of the property owner are under Section 30. Subsection 6 requires that if this property is designated as low income, it requires it to be such for 40 years. That means that the property has to be deed restricted if it's sold as low income. It means that every lease has to meet a certain financial formula, which you can require that the owner submit, I believe, to your zoning compliance, because he'd be out of zoning compliance if it were rented other than as a low-income unit. There are many restrictions that you can place should you be forced to approve this. I hope that you're able to deny it and deny it with prejudice, so we're not back here in 2 months. But if you're forced to approve it, I believe that you can place some severe restrictions on this property owner, including deed restriction and so forth. Subsection J of Section 830 says that the same criminal and civil penalties apply when this statute is applied as any other for fraud and so forth. So I believe that the state meant this to be a long-term process, not simply say, hey, we're going to rent this to the first guy, and then after that, all bets are off. The property owner has not assured you how he's going to make this low income for 40 years. It's incumbent upon him to present that to you, and I believe it's incumbent upon you, in this case and in ones in the future, to assure that all the dots are dotted on this. Thank you.
Thank you. Any final comment? If not, we go to the applicant. Seeing none, Mr. Sukanchik, for your rebuttal.
I think there's one man that wants to talk.
Oh, I'm sorry, sir. I didn't see you. I'm sorry. Come on. I apologize.
Good evening. My name is Andrew Seven. I live at 254 Homeland Street. I was compelled to speak tonight after my friends and neighbors have done all this great work. I've been sitting in the back of all these meetings listening. My real question here is, what is the burden that you have to prove for safety? And I sit back there and I ask myself this question. And as I think about it, I don't know the case law. I don't know the fire code. I don't know what bends need to be in the street for water to run off. I do have water in my basement. But my real question is, what is the burden for safety here? It turns out I'm one of the kids that plays on this street, okay? I spend a ton of time playing kickball in Marcy's driveway. I throw football between the Hammonds driveway, which is across from Mr. Sakonchik's, and the Andersons. I'm throwing baseballs with my son in front of my driveway 5 days a week at 4 or 5 o'clock in the afternoon. And when I think about the number of kids on this street, there's probably 25 to 30 kids between the ages of 0 and 10 now, a massive explosion in terms of the number of kids since I moved there 7 years and 2 months ago. And I look at it and I think to myself, you have these giant monstrosities over here, you have all these cars coming in all the corners, and my wife and I spend a lot of time, as do all the parents here, watching our children. And you can't, if you got more than one, it's hard to watch them going in opposite directions. So the question is, what is the real burden that we have to prove that there is a real safety issue from a traffic and a car perspective? So I ask you that question. I appreciate your time.
Thank you, sir. Is there any final comment? Seeing none, this will close the public comment portion of the meeting. Now we'll go to Mr. Sakonchik for his rebuttal, following which the hearing will be concluded. Mr. Sakonchik.
Good evening. Jim Sakonchik for the record. Concerning the many comments of traffic, I believe I have sufficient information in the record, and I stand by that information.
Sure. Commissioner Leslie has a question.
No. Mr. Sakonchik, I have a question for you. According to our 5.2.2 of our regulations, as the height, no building or other structure shall exceed the following height. Zone A, 2 1/2 stories or 32 feet, whichever is the less accepted dwelling is located in the 100-year flood zone. I honestly believe that we're above our height requirement on these buildings.
I make note to your regulations that in other zones, AAA, AA, R3, and R2, you allow 3 stories or 40 feet, whichever is less.
Yeah, but you're not in those zones, you're in an A zone.
That is correct.
And your building that you're proposing is above the height for an A zone.
In an A zone, you are allowed 2 1/2 stories or 32 feet.
Correct.
And that height is measured to the midpoint of the ridge of a roof, according to your graphics. So the plan here submitted...
According to your graphics.
That's correct.
Not according to this regulation.
Mr. Sakonchik, we'll let you proceed, and then if you want to come back to that, I don't want to interrupt your flow here and your... Okay. I think we've done already. I apologize.
Mr. Chair, I would agree. This is rebuttal time, so I would let Mr. Sakonchik make his rebuttal or not. He can choose not to speak here, and if there's any questions and the chair wants to entertain him, that's fine. But I would let him. This is just a rebuttal. He has opportunity to comment on the evidence that he's heard. So
yes, concerning the comments made about alleged problems with fire safety and comments made about issues of the height of the building. It is noted in your zoning regulations that in other areas of town you allow 3 stories or 40 feet, whichever is less. We are certainly within those guidelines. It is noted in zone B and C you allow setbacks on sidelines as small as 5 feet. We exceed those guidelines. So consequently, the people in charge of safety in town have to deal now with existing conditions with setbacks of 5 feet on sidelines. We exceed that. and they have to accept situations with three stories or 40 feet in height, and we are less than that. So consequently, we are in no way creating an unsafe situation. And in your definition in an A zone, you allow a height of 32 feet, and I even believe we conform to that, although it could be interpreted that this is a 3-story building. But again, I think this is a safe situation, and my design is very similar to the design this commission recently approved for the 12-unit affordable complex. That completes my rebuttal.
Thank you, Mr. Sakonchik. No questions?
No, that's fine. I have a question.
Commissioner Wagner, you had a question?
Thanks. I had a question about the lease. We heard some comment about the rental of the property, 214 Homeland. That's right, it's being rented now?
Yes, apparently we're not very popular in this neighborhood. My son and his wife have chosen not to move there, and they have leased
No, that's fine.
the
I'm not
property.
commenting on, I'm not taking issue with whether it's owner-occupied or it's a rental unit. But at one point, you had represented to us that it was a home for him. We heard testimony that it's now being rented. Is that right?
That is correct.
Yeah. And is the lease for the rental for the single unit, the one lot, or is the lease for the entirety of the, inclusive of the pool area?
My son owns 214. He has leased his property. I own 206. I have not leased my property.
We heard some testimony that the renters are taking care of the landscaping on your property. Are you aware of that?
I have given them permission to take care of the landscaping in exchange for permission to use and enjoy that adjacent land until such time that I have other uses for it.
So you've given them permission to take care of your land in exchange for what?
Their use and enjoyment of it in the interim. It is a verbal agreement.
We heard some testimony that there's a fence around the property.
Yes, because there is a pool on the property, there is a conforming safety fence around the pool, and at the same time, the pool is currently covered with a safety cover, and it supports people because my son accidentally tripped and fell on the cover, and he just walked off.
Does the fence incorporate the single-family dwelling and go around the pool? Does it overlap the two parcels?
The fencing does overlap the two parcels, that is correct.
So the area with the pool and the yard is treated as a yard for the single-family home?
I'm not quite sure where you're going there. I think I've answered the question.
Okay. We heard something about a sprinkler system. Is there a unified sprinkler system across both parcels?
I don't know much about the sprinkler system, but I believe what you're saying is correct.
Do you know if there's a sprinkler system on your parcel?
Yes.
Is that sprinkler system hooked into the sprinkler system on your son's parcel?
Again, that's my understanding. I personally haven't involved it. I'll ask my son. Yes. The answer is yes.
Is that controlled by the sprinkler system at your son's house?
Yes.
It's not functional.
For the record, my son mentioned it's non-functional.
Okay. But at one point, it was installed as a unified sprinkler system, and it was functional?
Yes.
Okay. Thanks.
Hearing nothing, I'm sorry, Commissioner Sutter.
Yes, your application, as you have already cited, establishes one affordable unit for persons with 60% of median income. Where is the affordable unit for people with 80% of median income?
Because we have 3 units proposed, not 6 units proposed, we do not have the privilege of having an 80% unit. If more units were proposed on this property, the next unit would be an affordable unit with 80%. So that's how it works.
Doesn't Section A6 of the statute establish 2 classes of affordable units? And in that case, you would need at least 1 affordable unit in each class to have a set-aside development.
I do not believe that is correct.
That's the plain meaning of the statute as it is read.
Maybe your interpretation. I make reference to the Ledyard case I put in the record. There, the court has approved 3 units as an affordable, complete affordable complex.
Thank you.
Sure, Commissioner Kennelly.
Mr. Shikanchik, one thing I was curious about, since we've heard testimony tonight that the unit, your son, the property your son owns where the single-family home is now being leased, is the lease that is arranged, you don't have to answer this, but I'm just curious about the future of the property. Is the lease that has been arranged with those renters a long-term lease, a month-to-month? Do they have any protections regarding
I believe that
what
is
you might do
private
with the structure
information.
they're currently renting now?
I believe that's private information.
I'm just asking if you want to.
Not relevant to the issue at
I was
hand.
just curious. Okay.
Seeing no further questions, this will close the public hearing on this matter. Thank you. And having no further items on the agenda, we will stand in adjournment.